Full Disclosure is producing a movie entitled The Cost of Courage. It's a documentary that chronicles the frightening story of Dr. Richard I. Fine, who took on the judges of the Los Angeles Superior Court. We were there in the courtroom at that historic moment when Richard Fine was arrested to begin his unwarranted 18 months of solitary coercive confinement. But even though we had petitioned the court, we weren't allowed to record the event on our cameras. We finally got a copy of the video footage of his arrest. We wanted to go back to that courtroom to record the moving speech that Dr. Fine gave moments before his arrest. It is essential to our movie because Dr. Fine meticulously identified how the Judge David Yaffe, was violating the law by sitting on the case. This sequence provides the explanation why Dr. Fine spent 18 months in jail. We petitioned the court to get access to an empty courtroom and got the bureaucratic runaround. For us, this became a First Amendment issue. As the media, we have a right to use public facilities to discuss public issues. While fighting the resistance of the court, we noted that CNN was given full access to the same courtroom when they did a short segment on Dr. Richard Fine. Why shouldn't Full Disclosure have the same access? In an apparent attempt to exhaust us, we were shuttled from one court official to another. We were told to contact the facilities manager, and then the presiding judge, and then the court counsel, and then back to the facilities manager. We filled out form after form and submitted our proof of insurance and jumped through every hoop the court threw in front of us. After we had complied with every requirement, the only response we got was silence. So we decided to force their hand. We contacted our friends at Judicial Watch. Their first approach was very measured and not confrontational at all. Paul Orfanedes, their director of litigation, got a more definitive response.
And then we wrote a letter. And then when we wrote a letter, they wrote us back saying, no, you wouldn't be allowed this access. So we filed a lawsuit on your behalf.
He described the thinking behind the lawsuit.
Federal property that the government, federal or state or county, whatever sort of government property that is made available for public use, the government can't deny you access to that unreasonably. It can't act arbitrarily or capriciously, and it can't discriminate against you on the basis of your viewpoint.
These are solid, reasonable arguments that should easily stand up in court, and that's who we sued.
So we filed this lawsuit against the Chief Judge of the LA County Superior Court, against the judge who presides over Department 86, and against the General Counsel to the LA County Superior Court, who authored some of these letters saying no, for violation of your First Amendment rights.
And he described the result of this solid, reasonable lawsuit, which the court dismissed with prejudice.
We had a hearing yesterday in front of Judge Manny Real. Well, it wasn't much of a hearing. It was more of a reading of a decision, I should say. That apparently is what the court's process is. The court granted the motion to dismiss. It said that these facts that we had pled in our complaint, they don't add up to a claim for a violation of your rights.
What? The facts don't add up to a claim for violation of our rights? Mr. Orfanedes had difficulty understanding their reason for dismissing our suit.
The fact that you fulfilled all the criteria for being allowed this access, and that they couldn't even give you a reason for why you were being denied access, that to us shows just the arbitrary and capricious nature of it, the fact that they didn't have a good reason to deny you access.
Interestingly, the court hired the world's largest, most powerful law firm to represent them, Jones Day. Who paid for this high-powered team of lawyers to stop our little video recording session?
We don't know how it was that Jones Day was hired to represent the court. It just happened to be one of the same attorneys that represented the court in the judicial benefits case. And there's no opportunity for us to find out. There's no transparency, there's no accountability in any of this sort of court administrative process.
Just released a few weeks ago was this massive report on the Administrative Office of the Court by the court-appointed Strategic Evaluation Committee. This report took issue with some of the top-down edicts by which the court operates. We asked Mr. Orfanedes if the decision to dismiss our suit came from way up the food chain. But according to this, it would appear that the decisions are being made at a higher up level.
It could be. It could be. I still think, well, we don't know. I mean, we don't know who was making the actual decisions. We believe in your case that it was the chief judge, that it was the general counsel, and then it was the judge in Department 86. We don't know what role the administrative office might have played. But this report does highlight the sort of the lack of transparency in anything involving sort of the administrative process and operation of the courts. And this report, it's pretty horrible in terms of there being a lack of transparency and a lack of oversight.
The dismissal of our lawsuit never addressed the issues that Judicial Watch brought forward in the suit.
There certainly is no reasonable or rational explanation. I mean, you asked for approximately a half hour's worth of time. Any time the court was available, any time the courtroom was available. There's no. You satisfied all the conditions and requirements and all the licensing application process. There's really no reasonable reason for them to have denied you access.
But they did. The court is supposed to dispense justice according to the rule of law. Somehow, that doesn't seem to work out like that.
The California court system is an enormous court system, and you end up with bureaucracies and entrenched interests and egos and personalities and ambitions and all that. And sometimes justice is maybe what the purpose of that is supposed to all be about, but it gets somehow lost in the shuffle behind all the bureaucracy.
We asked him if he thought this was an issue worth pursuing on appeal.
Absolutely. I mean, I think one of the things that this lawsuit, one of the things that it has the potential to do is to force the court to develop some sort of regular process and procedure for considering these types of requests. I mean, we know that they allow the public to make use of their court facilities after hours. There's a form, but yet there really aren't any rules or regulations or guidelines. There's no set process or procedures. I mean, you basically got a runaround in terms of you made multiple requests to multiple entities. Finally, you were told to file this commercial application with the court facilities office, and you went to great lengths, did everything they told you to do, and ultimately the answer was no, no, no. But hopefully, one of the things this lawsuit can do is to spur the court to come up with some sort of regularized process for making these sorts of, for considering and responding to these kinds of requests.
He's enthusiastic about seeing this case to its end. In light of the fact that the budget crisis is causing the bureaucracy to abandon 52 courtrooms, they should be able to find some way to squeeze in full disclosure so we can complete our documentary.
If we go to the appellate court and the appellate court reverses, we'll get the case back, and then we'll get some discovery. We'll be able to ask some questions to the court about its processes and its thinking behind not just what happened here, but how this process is supposed to work, that they've got 52 courtrooms that they're not going to use anymore, and they're not going to let the public use them either. It just doesn't make any sense.
We want to know what you, the viewers, think. Please respond to our survey and leave your comments below. Number 1, do you think the court's arbitrary decision to ban Full Disclosure Network's First Amendment right to use an empty courtroom should be appealed? Yes or no? Number 2, do you think that the mainstream media outlets will support full disclosure to challenge the court's arbitrary ban of the Full Disclosure Network? Yes or no? Number 3, why was CNN allowed to use the courtroom and not full disclosure? Do you think the court is showing favoritism to the mainstream media? Yes or no? Please be sure to leave your comments below. I'm Leslie Dutton. Thank you.